Item number 1.
May please, Your Lordship. Well, it's pursuant to the directions passed by this Honorable Court on the last occasion.
This is for condonation of delay today.
Delay is condoned already. I'm sorry, Millet, in this matter there is no...
The MC is the stay application.
stay.
Okay.
And my lords have already passed an interim order, my lords. By order dated 17/12, my lords, some interim directions have been passed.
Yes, please.
Well, it's pursuant to the directions by this Honorable Court on the last occasion, that is on 29/1, we have informed the writ petitioner, my lords, also verbally about the matter coming up today. But I don't think there's any representation from them.
You are appearing for?
I'm for the Union of India.
If your lordships permit, my lords, I can just place the facts on a gist. The reason why the writ petitioner is not appearing is, my lords, it really does not affect him. What had happened, my lords, here is, my lords, this matter pertains to the settlement of a RO dealership, my lords, from BPCL. So initially, my lords, there was a writ petition filed, which is WPC number 74 of 2024, where, my lords, the grievance of the writ petitioner was non-disposal of his representation. So, my lords, by the time the matter came up before this Honorable Court, my lords, before the learned single judge, the representation had already been disposed of. So, my lords, he withdrew that writ petition with liberty to challenge the representation. Subsequently, my lords, a writ petition was filed challenging, my lords, the disposal of the representation. And, my lords, that came to be registered as WPC number 112 of 2024, where the impugned judgment on order has now been passed. Now, it was nobody's case before the learned single judge, my lords, that the RO dealership has been settled with anybody. As a matter of fact, my lords, on instructions, I can say, make the statement before your lordships that it is not settled even today. The learned single judge, my lords, on the basis of our affidavit, which I'll take your lordships, my lords, where we say that there was a draw of lots. And in the draw of lots, my lords, one particular person came out as successful. And, my lords, the process, there is a brochure, my lords, for settlement of RO dealerships all across, which is common to all oil companies. That process has been initiated, my lords, where that verification and other things are going on. Now, the learned single judge, my lords, takes exception to the fact, saying that you have not informed this court that you have already settled the RO dealership with somebody in the earlier round of litigation itself. So, therefore, my lords, the directions are there in this judgment, saying that, my lords, costs are imposed and some disciplinary proceedings to be initiated against some unnamed officials of the petitioner company before your lordships. I'll quickly just take your lordships to the relevant portions, my lords. If my lords have the impugned judgment on order, my lords, page 193, the relevant paragraph would be paragraph 11. My lords have paragraph 11. My lords. May I just read? Having heard learned counsel for the parties, though the main issue in question is the rejection of the application of the petitioner on account of mismatch of one alphabet in the uploaded PAN card number, another aspect that also deserves consideration is the manner in which the respondent company has conducted itself in the course of the proceedings. As it has been submitted that the first writ petition, that is WPC number 74 of 2024, had been filed against non-disposal of representation of the petitioner on 18/3/2024, which was then withdrawn on 12/4/2024 on receipt of the order that the representation had been rejected by an order dated 16/3/2024. Malas, if I may just pause here. Malas, we are aggrieved by the subsequent portions. Malas, I'll just take your lordships. The said information was contained in the affidavit filed on 10/4/2024 by the respondent company in WPC number 74 of 2024, which, however, did not disclose the fact that the said RO dealership had already been settled with another party on 22/2/2024. This is revealed from the records of disposed of WPC number 74 of 2024, which has been requisitioned by this court in the course of hearing of the instant writ petition. Well, it's para 12.
Yes.
May I continue, Malas? It is only in the affidavit filed by the respondent company in the instant writ petition challenging the rejection of representation that it was revealed that the RO dealership had been awarded to another party as far back as in 22/2/2024. Interestingly, in the course of the proceedings in the instant writ petition, this court, by order dated 22/4/2024, at the motion stage itself, had directed in the interim that there shall be no settlement of RO with any other party, and this interim order was then continued by successive orders till the last extension on 22/8/2024, without any objection by the learned counsel for the respondent numbers 2 and 3. The respondent company, in spite of this fact, did not deem it fit to apprise this court at the initial stage itself that the dealership had been awarded to another party and continued in the charade as if the matter was still available for consideration. And thereafter, my lords, if your lordships kindly turn the page and come to paragraph 15. If my lords have para 15. However, reverting back to the suppression of material facts by the respondent company, which it appears to have been made knowingly in judicial proceedings before this court, the same is deprecated, and it is expected that necessary appropriate disciplinary action be instituted against the officers concerned who are responsible for misleading this court. It is also further provided that respondent number 2 and 3 for such conduct shall pay a cost of rupees 1 lakh to be made over to the Meghalaya State Legal Services Authority. So this is, my lords, the sum and substance of the matter. If I may quickly just take your lordships to my affidavit file.
Now the representation was made in April.
My lords.
Now, according to you, there was no settlement of award of dealership in February.
Even today, my lords, it's not done. Only the draw of lots has been completed, my lords. After that, the procedure for, my lords, the settlement is still on. We've not done, there's no settlement even today.
From where did his lordship get this fact?
My lords, I'll just take your lordships to the relevant paragraph, my lords. If my lords kindly have my affidavit at page 169. Paragraph 7 of that, my lords, at page 175. My lords, may I kindly have a look at paragraph 7, my lords, at page 175, if I may read. That the writ petitioner, as has been filed by the petitioner, is also bad for non-joinder of necessary parties, inasmuch as the draw of lots for the concerned retail outlet has already been conducted by BPCL on 22/2/2024. Even before the filing of the previous writ petition by the present petitioner, that is PC number 74 of 2024. In the said draw of lots, Shri So-and-so, resident of So-and-so, East Rinja, Shillong, East Khasi Hills District, Meghalaya So-and-so, had emerged successful. Therefore, the outcome of the present writ petition has an effect on the interests that that have now vested on Shri So-and-so, and he has not been impeded by the petitioner, despite being a necessary party. So this is from where, my lords, the learned single judge, my lords, takes the view that there has been a settlement of the pump. Now, the writ petitioner, my lords, I must draw your lordship's attention to this. If my lords kindly have a look at the impugned judgment again at paragraph 6, page 190. The writ petitioner himself, my lords, contends that no third-party right is created because there is no settlement. May I just read paragraph 6, my lords, at page 190.
Yes.
Paragraph 6, my lords, if my lords can have a look. On another limb of submission, the petitioner, on the assertion by the respondent company that the said RO dealership has since been awarded to another person on 22/2/2024, before filing of the previous writ petition, that is WPC number 74 of 2024, the learned counsel has contended that the settlement with the third party is provisional, more so with the letter of intent award not being brought on record, and as such no third party right has been created till date.
No, but what happened after the draw of lots?
My lords, if I may take your lordship, my lords, to page 49. From here onwards, right? Now, lords, we've annexed the brochure. And if my lords kindly have a look at, my lords, page 48.
No, has it been finally awarded?
Not awarded. Even today, my lords,
The
not
process is going on.
process is going. It is at the stage of verification, field verification, my lords.
No, but when this order of 22/2 was passed
My lords,
for considering the representation,
my lords.
so at that time it was, these facts were available to you, that draw of lots had taken place and so and so.
My lords, if I may, there was no direction for us to consider because the writ petition was withdrawn, my lords. If I may take your lordships to the order passed in the earlier writ petition, your lordships would find that at page 119, my lords. The relevant portion is at page 120. If my lords have it, my lords, this is the order dated, it's on the previous page,
12/4.
12/4, my lords. There was simply a prayer made before the learned single judge, my lords, that I may be permitted to withdraw with.
No, but on 22nd February, the order was passed that you consider the representation.
My lords, on 22nd, there was the draw of lots. There is no order from this honorable court to consider, my lords. The first writ petition came to be filed in the month of March 2024. That's after the draw of lots.
First writ petition filed on 18/3,
18/3/2024.
withdrawn on 12/4.
My lords. And the settlement,
And
my lords, the drawing of lots was prior to that. On 22/2, my lords, was the draw of lots.
on what terms you rejected the representation?
My lords, there was a mismatch in the PAN card. So to that extent, my lords, the learned single judge holds that it is a non-rectifiable defect and that cannot be considered. Against that, there is no appeal before your lordship.
No, but you did not say that on 22nd February, uh, upon drawing of lots, this.
I pointed out, my lords, paragraph 7.
No, when you rejected the representation, then the representation was no good because the contract had already been awarded or in the process of being awarded.
In the process, my lords, at the most, it can be said that it could be in the process. Some right had been created in respect of somebody else.
You were just making the usual verifications, perhaps.
My lords.
So that ought to have been pointed out when you rejected the representation.
My lords, in the only consideration that was there for us, my lords, while the representations was being rejected, was only on the ground that
No,
there
when you
was a
had
mismatch.
accepted the tender or offer of
My lords.
the dealership of one party, and the process was only for making a formal finalization of it, then in rejecting the representation, with the PAN card, etc., was not relevant anymore. The defect in the PAN card, etc.
My lords, which is why in the subsequent writ petition, when we filed the affidavit, we brought it on record that in the draw of lot, somebody was successful. At the first instance, my lords, when we filed an affidavit, we brought it on record.
While rejecting the representation, you should have
the-
mentioned that it is infructuous because we have already accepted somebody.
In the rejection, of course, my lords, that is not there. I cannot add something that is not there. But the representation was only restricted to the issue of, my lords, considering his case that there was a typographical error and that's why his application be accepted. So we said that is a non-rectifiable defect, my lords, we cannot accept it. And he was conscious of the fact, my lords, I've pointed out, my lords, he was conscious of the fact that there's somebody, but there is no right created on that person.
Why do you think the petitioner is not, the petitioner has been awarded the contract? Why the petitioner is not appearing before it has, because it has gone to somebody else?
Probably, my lords, he's not pursuing the matter because even the rejection of his case regarding the non-rectifiable defect of the PAN card, no appeal has been preferred. The substantial question, my lords, which was there before the learned single judge insofar as the PAN card, against that there has been no challenge before this honorable court.
Brother. I don't think there's any case for any TP. Unless it is shown that the acceptance was backdated and the petitioner is not coming.
This has no stickiness. What is it?
Demand it. We want all these facts in it. Why should we go into the of the disciplinary to go into these facts in detail?
Who's the disciplinary?
Well, it's 2 pages, if I may just point out to your lordships.
Disciplinary action. We can say that you make a preliminary inquiry regarding all these facts, then initiate this. Then we need not send it back to the trial court. You can do.
Let's 2 pages, 2 queries that had fallen for my lords. Let's say.
You please listen to our order, it will be clear.
Well, it's
Or you can make those submissions before we pass our order, yes.
well, what had fallen for my lords, my lords, is the representation, the rejection order, my lords, is at page 148. Rejection, right. Yeah, it says rejection. That's what I'm saying. With my lord.
Yes.
Well, this is dated the 6th of January 2024, where Malas, the initial rejection at paragraph 3, your lordships would have seen. We regret to inform you that your candidature has not been found to be eligible for RO dealership on the basis of documents submitted by you for reasons as detailed below. Mismatch of PAN number mentioned in application number so-and-so with one that is uploaded. That's one, Malas. Against that, Malas, the representation that was made is in the next page, Malas, at page 149. So, let's here again, he says, with reference to your email number so-and-so, let's skip that. Paragraph 2, my lords. In this regard, it is pertinent to mention herein that the same was not a deliberate mistake, but was just a typo error, and I had no wrong intention. I am further submitting an affidavit regarding the same. In this connection, I humbly request you to not cancel my candidature for a minor, undeliberate typo error, for which your kindness, I shall act of kindness, I shall remain ever grateful. So this was the sum and substance of, my lords, the representation that was there. So otherwise also, my lords, that occasion what came from my lordship, my lords, we had no occasion to inform him of anything because the first rejection is on 6/1, my lords, that's prior to even the draw of lots. So even at the initial stage itself, it had failed.
And then the rejection order?
My lords, the subsequent rejection order at page 159, my lords. The typed copy is at page 159, my lords. Please refer to the letter received by us on the subject in connection with the same. We would like to refer to page 33, section 2.23, point number N of the brochure of the so-and-so, which is available in the website. Quote, PAN number mismatch, incorrect PAN number does not belong to the applicant, unquote. The above deficiency has been observed in your application, which has also been mentioned in our email dated 6/1/2024. The above deficiency in the application form for RO dealership selection is non-rectifiable and as such will not be considered for further selection process in line as with mentioned in the brochure of 2024. What I'm trying to humbly submit before your lordships is, my lords, that is even before he enters into the zone of consideration, because there is a defect in the application, my lords, the application itself is rejected. So the entire matter was circulating on that. Once the second writ petition came to be filed before this honorable court, my lords, at the first instance, we brought it on record that there was a draw of lots on 22/4. I'm sorry, my lords, not on 22/4. 22nd February, my lords.
Yes. Please take them. On earlier occasions, when this appeal came up for consideration, the writ petitioner or respondent, the respondent with petitioner was not represented in court. We had passed directions upon the appellant's learned advocate to notice him, which has been duly done. But even today, none represents him. Paragraph. The appellant is aggrieved by a judgment and order dated 2nd December 2024, passed by a learned single judge of this court. The appellants are, full stop. The principal appellant aggrieved by the order is appellant number 2, is appellant number 1, Bharat Petroleum Corporation Limited. By the impugned judgment and order, quotation, appropriate disciplinary action be instituted against the officers concerned who are responsible for misleading the court, unquote, has been directed together with imposition of cost of rupees 1 lakh. The paragraph, the subject matter of the writ petition in appeal is an RO dealership of the appellant. The retail outlet dealership, you're right, in the state of Meghalaya. On the road connecting Rambrai, Rambrai, and Kinsai, Kynsai, West Khasi Hills. Mr. Paul Learned, senior advocate, appearing for the appellant, has very strenuously placed the following facts before us to support his argument that this judgment and order ought not to have been passed. The tender process, consideration of the tenders for allotment of this retail outlet had started sometime in or about early 2024, early January 2024. Next, on 6 January 2024, the appellant had written a letter to the respondent, writ petitioner, the respondent writ petitioner, that his application was defective. For discrepancies in certain documents submitted by him, namely, mismatch in PAN card between PAN card number before mismatch quotation mentioned in application form bracket B capital YJ PDO 795 capital F bracket closed with the one that is uploaded bracket BJYPD 0795F. For your guidance, see page 148. On 15th January 2024, the respondent writ petitioner replied that the above mistake was not deliberate on his part, but a quotation typo error. On next line, on 22nd February 2024, Shri Lumborlang, Lumborlang, Wandsworth, see page 175. Was declared the successful bidder on a draw of lots, subject to some routine verification and formal award of the dealership. Paragraph. The respondent writ petitioner filed the first writ petition, bracket WP within bracket C, number 74 of 2024, challenging the non-consideration of his above representation by the appellant. It appears from the records that this representation had been rejected by the appellant on 16th March 2024. Full stop. Because of this, the respondent writ petitioner withdrew the first writ petition on 12th April 2024. Paragraph, learned single judge has taken exception to this conduct of the appellant, remarking that they did not, quotation, disclose the fact that the RO dealership had already been settled with another party on 22/2/2024. Paragraph. Principally on this basis, the learned judge directed disciplinary proceedings against the officers of the appellant. Paragraph. Learned counsel urges the following points before us. Stop. Next line. First, there was no settlement between the appellant and any other party. Full stop. With that, Sri Lamorang Wanswet was declared as the successful bidder on in a regular tender process, and there was no question of any private treaty between the appellant and the successful bidder. The representation of the respondent writ petitioner, like the representation of the respondent writ petitioner, was concerning a short issue of a defect in supply of PAN card number and had been dealt with accordingly. A formal order is yet to be issued in favor of the successful bidder. There was no intent on the part of any officer of the appellant to overreach the court. Paragraph. According to us, the mistake which the dealing officers of the appellant made was not to apprise the officer dealing with the representation with regard to defect in the number of the PAN card that the contract had already been more or less been awarded in favor of another party, and that the exercise about correction of the PAN card number in the PAN card was redundant. Nevertheless, prima facie, we do not find that there is any irregularity or misconduct committed by any of the officers of the appellant. Full stop. As we are sitting as a court of appeal, we do not have access to all the records of the case. It is to be ascertained from the records whether the drawing of lots, as Dr. Paul points out, was made oblivious of the filing of the writ petition, or whether the successful bidder declared to defeat the writ petition, declared in hot haste to defeat the writ petition, or whether this acceptance of the bid of Sri Lombrov was backdated or not. These are the facts which are relevant and are not gone into by the learned trial judge, and would and if proved or disproved, would point towards the culpability of the officers. Now would point towards the conduct of the officers of the appellant. Paragraph. In those circumstances, there is no warrant right at the moment to initiate disciplinary proceedings. Full stop. We direct the competent authority in the appellant company to initiate a detailed preliminary inquiry with regard to this tender, on the basis of our observations above, and if it is found that any officer or officers have indulged in irregularity or misconduct, then only disciplinary proceedings are to be initiated against him or them. But it is not to be initiated if it is found that there has been a bona fide error of judgment or mistaken notion about some state of facts, but the officer has acted honestly in discharge of his duty. Paragraph. With those observations, this appeal is disposed of. Yes. The award of costs is set aside. With those observations, we dispose of this appeal.
This para 15 of the judgment would stand modified to that extent.
Yes, yes. The impugned judgment and order is modified to the above extent.
Item
number
Now,
2.
any benefit of doubt is to be given to the officers.
Item number 2.
My lord, this is also an appeal from order of the learned single judge, my lord.
Yes.
My lord, your lordship, by last order, was directed us to prepare an informal paper book, my lord, and furnish it to them. But there was some delay on my part, my lord. But today we have been able to complete the paper book, my lord, and today we have served a copy on them, my lord.
You file it, is it ready?
My lord, we have given a copy and we will file it in the court today, my lord.
All right.
The matter is taken up next week or week after that.
My lord, my lord, my-
The delay in filing the paper book is condoned. The appellants are allowed to file the informal paper book as directed by our previous order. By 4th, you file it by 4th.
We are filing it today, my lord.
Today.
Today. It's ready, my lord.
We are saying by 4th, if you file it today is very good.
My lord.
my lord, this case appeal is barred by limitation. Threshold limit of the Government of India Ministry of Finance, order dated 2/11/23.
Threshold limit.
Threshold limit. But for filing appeal before the High Court is 1 crore, but in the instant case, seizure value of the battlenet was 88 lakhs, but the learned single judge has awarded compensation for unlawful disposal of the goods of rupees 60 lakhs. So it is below 1 crore. So this point can be decided first. Appeal should be dismissed on threshold limit. I have submitted evident objection petition on 21/8/2024. I have objected that it is barred by limitation.
It's a monetary limit, my lord.
Monetary limit, threshold limit.
But our cases, my lord, these are the writ proceedings, my lord. And those circulars.
This is covered under this, all appeals, my lord, under these instructions. I refer page number 15, my lord, of my objection petition.
What has the learned judge directed?
My lord, here what happened, my lord?
I directed return of the goods.
Return of the, they have destroyed, my lord. Can I say or you will say?
No, the learned judge has directed return of the goods.
My lord, what happened, my lord? The betel nut was seized from them, my lord. And we sent it for a laboratory test report, and the food laboratory said that it is unfit for human consumption, my lord. And then in the initial round of adjudication proceedings before the department was successful, and we disposed of the goods by destruction, my lord, because it was otherwise also unfit for human consumption. Subsequently, they filed a departmental appeal, my lord, before the tribunal. They succeeded in that appeal. Then they came before this honorable court by way of writ petition, my lord, saying that, asking for refund of the money value, my lord. The learned single judge is directed to us to refund 60 lakh rupees because ultimately they succeeded in the appeal. Since the goods are not available anymore, so to pay the money.
My lord, the matter went to Supreme Court also.
Serving a copy at least 5 days before the date of hearing of the appeal. List the appeal for hearing on February 18th.
18th February, I will be out of station, my lord. So,
When you want it?
10th?
No, after
Okay, after 18th, 20 or 21.
All right, on 20th February.
Okay, my lord.
The the point of maintainability of this appeal on the ground that it is below, that the value involved in this case is below the threshold limit, shall be considered first.
Yes, my lord. So, 21 or 22, my lord, because I will be out of station on 18th. So, any day after 20.
22 is Saturday
Okay, then
21st.
or 24th.
24th. Much obliged.
Deep.
Item number 3.
Yes.
May I please, Your Lordship, in this matter, I'm praying for adjournment, Your Lordship.
Union of it is your appeal.
It's my appeal.
Your Lordship, the conducting counsel is Mr.
You
Pathak.
agree?
But the interim order is there, my lord.
Ready for hearing?
It's otherwise ready for hearing.
All right. On the prayer of learned counsel for the respondent, this appeal is adjourned till 24th February.
Your Lordship, if I may pray for 18th February, Your Lordship, as there is another matter here, Mr. Pathak is.
All right, 18th February. The subsisting interim order will continue.
But if Lordship pleases informal paperwork that has not been prepared is matter. But otherwise the material is on record, my lord. I have annexed everything. If Lordship desires, I can do that also. My lord.
All right. In the meantime, advocate on record for the appellants shall prepare and file an informal paperwork in this court. By 14th February,
My lord.
serving a copy thereof at least 5 days before the date fixed for hearing of the appeal.
Deeply.